fundamental rights, more specifically Article 12 of the Constitution of India. In this discussion, we will look at the meaning of Article 12 and the relevant case laws. To begin with, what are fundamental rights? They are listed in Part 3 of the Constitution, and they begin from Article 12 and conclude at Article 35. In other words, Articles 12 to 35 of the Fundamental Rights chapter existing in Part 3 of the Constitution of India guarantees to every citizen of this country the claims and entitlements that he or she has a right to. Now, if we have such fundamental rights, the responsibility of ensuring that each one of us can exercise our rights lies upon the state. It is therefore quite apt that the very first article, Article 12 of Part 3 titled Fundamental Rights, provides us the definition of the term state, and we will see how in a moment. Please also note, however, that the same definition of state is also found in Article 36, which is the first article again of Part 4 titled Directive Principles of State Policy. It is extremely important here to remember that this definition of state is applicable only for Parts 3 and 4 of the Constitution. What this means is that only for the Fundamental Rights chapter and the Directive Principles of State Policy chapter, this definition of state will be applicable and not for any other part. Moving forward, therefore, if Articles 12 and 36, both the first articles of Parts 3 and Parts 4 of Constitution, define state, what is the state? And let's look now closely at the definition given in the Constitution to answer this. Article 12 begins by saying, in this part, unless the context otherwise requires, the state includes. Before we go further, let's stop for a moment on that word includes. That word itself makes the definition of state expansive. The framers of the Constitution used the word state, therefore, in a much wider sense than the ordinary sense. The word includes itself suggests that the definition is not exhaustive. We now look into the full definition. So we will read that again. In this part, unless the context otherwise requires, the state includes the government and Parliament of India and the government and legislature of each of the states and all local or other authorities within the territory of India or under the control of the government of India. So looking closely, we can see that the important segments of this definition, besides the term includes in red, are the other distinct four. First, the government and Parliament of India, suggesting at the center, government and legislature of each of the state, suggesting the state level, all local, the local level, and the other authorities. Now, let us try and analyze what each of these components would imply. So therefore, Article 12 really comprises of four main components as highlighted in blue. It gives therefore a very, very extended and expansive view of the term state. Let us look closely into the first four components as given in the definition. The first component is the government and Parliament of India. What this means is that the term state, for the purposes of chapters 3 and 4, chapters on fundamental rights and the chapter on directive principles of the Constitution, implies by the term state not only the government but indeed the entire parliament. So, therefore, not only the members of the ruling party which form the government itself, but also, say, all members of the opposition, including the independent members who sit in the parliament, will be considered to be state under Article 12. Moving on. The second segment is a segment which provides us government and the legislature of each of the states. Again, the definition here will include not just the party in power at the state level, but indeed all members of the entire Vidhan Sabha, where it is a unicameral house, and the Vidhan Sabha as well as the Vidhan Parishad, where it is a bicameral state legislature. The third component provides a very interesting segment of the definition of state. It talks about local authorities. Local authorities is indeed local self-government which exists at both urban as well as rural areas. The definition of local authorities in fact has been provided under the General Clauses Act 1897, Section 3, subsection 31. And it includes authorities at both the urban areas as well as the rural areas. So the urban areas will therefore have the municipal corporation, improvement trust, district board, mining settlement authority, and so on and so forth, while the rural areas would be locally self-governed through the village panchayat and other authorities for the purpose of local self-government. So therefore, this is the third tier of the definition of state. Now we come to the fourth component. The fourth component is that of other authorities. Interestingly, there is no definition of other authorities, not in the Constitution, not in the General Clauses Act, nor in any other statute of India. But what we have is indeed judicial interpretation of the term other authorities. And this is that area of the discussion of the state which is perhaps the most interesting in Article 12 and Article 36. To understand this better, let's consider this idea of the Government of India. The Government of India is a social welfare state. What does it mean? It means that the Government of India performs several functions which are of public importance, right? And those functions are performed through the conventional governmental departments, but also greatly now through autonomous bodies that exist outside the governmental structure. And these are bodies which could be companies, which could be corporations, and so on and so forth. So therefore, what we have here is that the Government of India is, strictly speaking, a body which is acting more and more with traditional actors, but also with actors which are out there performing necessary duties which would otherwise be considered state functions. So hence the term other authorities, while there is no definition as such, can be seen through judicial interpretation, through various case laws which have really brought about an evolution of the understanding of the state under Article 12 of the Constitution of India. Let us take a look at the major judicial pronouncements and examine the facts and circumstances of each of these cases. Right. We will look at this very important case, the University of Madras versus Santabai. This was perhaps the single most important case which led to beginning the question of interpreting, judicially examining the question, the term state. Now, let us do a picture puzzle. If I were to put before you the names of fruits such as guavas, cherries, apples, and ask you to complete the list, you are, in all probability, going to name another fruit. What have you done here? you have applied the rule of like nature or of the same type. That is the rule of ejusdem generis. In the case of University of Madras versus Santabai, a question arose before the Madras High Court whether the University of Madras was other authority under the definition of state. The court held that other authority indicated authorities of like nature or the rule of ejusdem generis. This indicated that it would apply only to the authorities that are governmental or perform sovereign functions, and therefore it cannot include natural persons or juristic persons such as a university unless it is maintained by the state. Moving forward, we come to the second case law in this regard, the case law of Ujjambai versus State of Uttar Pradesh, 1963. In this case, the court rejects this restrictive interpretation. It held that the ejusdem generis rule could not be resorted to, arguing also that even in the case of the first three components, specifically the government and parliament of India, the government and legislature of each of the states, and all local authorities, there is no common genus which runs through these named bodies. Therefore, it is not necessary that other authorities need always indicate authorities of like nature. The third case was the case of the Electricity Board Rajasthan versus Mohan Lal. Here, the Supreme Court held that other authorities will actually include all authorities, and all authorities to actually mean every body which is created by the constitution or statute. It would also mean that where the power conferred is of commercial nature, the same will not exclude the concerned authority from classification as other authority. Thus, the question that whether the Electricity Board Rajasthan, which was established under the Electricity Supply Act, which was a statute, could be held to be other authority under the definition of Article 12, was held to be true in the same way that any act which is of commercial nature, right, or trade or commerce that was carried out by the Electricity Board of Rajasthan because of its function in a state capacity would not really exclude the board from the definition of the term state as used in Article 12. What this means is that the Electricity Supply Act mandates that the Electricity Board of Rajasthan is required to carry on activities in the nature of trade or commerce. And it is again a body which has been created by the statute, the Electricity Supply Act, and therefore just the fact that it carries out a commercial nature activity will not exclude this body from classification as other authority under the definition of Article 12 as state. Moving forward, the case law 4 is a very interesting case law. This is for the first time a reiteration of the Electricity Board Rajasthan's case, and it held that the statutory bodies of LIC, ONGC and FCI are held to be other authorities and fall within the purview of Article 12, because this phrase other authorities will also include all corporations created by the statutes. So in other words, statutory corporations or agencies such as the LIC, ONGC or FCI are nothing but instrumentalities, right? Are nothing but agencies of the state, and they carry out businesses or functions which are necessary to be carried out, in the sense that without such functions being performed, the state activity will suffer, and therefore they would also be considered to be part of Article 12, other authorities. We come now to case law 5, which is R.D. Shetty versus International Airport Authority. The court here pointed out that corporations acting as instrumentality or agency of the government will obviously be subject to the same limitations as the government itself. By holding that, it automatically applied and extended the previous case of Sukhdev Singh versus Bhagat Ram. And what it also did is, it provided for clear limitations upon the bodies which act as state under other authority definition. This same line of approach with regard to the meaning of interpreting other authorities was also confirmed finally in 1981 in Som Prakash Rekhi versus Union of India. It said that not only is a company which is registered under the Companies Act also to be considered as authority, but clearly such body is to be considered as a creature of the statute, a limb of the government, an agency of the state. In this matter, the Bharat Petroleum Company Limited, the BPCL, was being questioned as to its identity with regard to state under Article 12. And it was held that while it is registered as a company under the Companies Act, the same would not really expel it from its definition of inclusion under Article 12 because it functions as a limb of the government. The matter of defining other authorities has really come to its logical conclusion, we might say, in the case of Ajay Hasya versus Khalid Mujib, AIR 1981, because this case, the Supreme Court had the opportunity to determine the factors relevant for deciding whether a body is an instrumentality or agency of the state, and thereby it extended the definition to include the Indian Statistical Institute, the Indian Council of Agricultural Research, Sainik School Society, UP State Cooperative Land Development Bank, Steel Authority of India, Regional Rural Banks, Post Trusts, and so many others into the definition of other authorities, implying therefore that there was a vast majority of factors that were necessary to be examined to see whether a body fulfilled the test of instrumentality or agency. Now, these were the 6 significant clauses that the celebrated jurist of Supreme Court, Justice P.N. Bhagwati, provided to determine whether a body is an instrumentality or agency of the state. The first of which is if the entire share capital of the corporation is held by the government, where the financial assistance of the state is so much as to meet almost entire expenditure of the corporation, where the corporation enjoys monopoly status which is state conferred or state protected, existence of deep and pervasive state control, if the functions of the corporation are of public importance and closely related to government functions, if a department of the government is transferred to corporation. So if any of these 6 factors are seen to be satisfied, they would be considered to satisfy the test of other authority under Article 12 of the definition of state. Therefore, any body which has either of the 6 functions as determined by Professor Justice P.N. Bhagwati would classify as a state. Thus, to conclude, we will once again look at Article 12, the way in which it is provided under the Constitution, and it says that in this part, unless the context otherwise requires, the state includes, thereby making this definition exhaustive, remember, the government and Parliament of India, the first level, the government and the legislature of each of the states, second level, and all local or other authorities, third and fourth level, within the territory of India or under the control of the Government of India. With that, we conclude this discussion on Article 12 of the state. Thank you.